So thank you everyone for coming tonight. My name is Anthony Bolognese. I am a freelance photographer based in the DC area, and I put this event together just because I saw a lot of hubbub about this bill and wanted to clarify things for myself because I've tried reading it and it just doesn't work. I didn't study law. I don't know what it means. I fall asleep trying, so figured we'd find an expert. Um, I am a member of the leadership team of Freelance DC, which is an engaged community of freelancers dedicated to supporting each other and continually working to protect and improve the lives and rights of independent contractors in the DC area, and hopefully we can help do the same across the country. This is a Freelance DC sanctioned event, but doesn't represent the beliefs of the group as a whole. I did create this event to learn more about the facts of the PRO Act myself and will not be advocating for or against it on behalf of myself or Freelance DC. In order to kind of delve into that, we have Diana Bardes here with us. She is a labor attorney devoted to advising both private and public unions on a variety of labor and employment issues. She also represents individuals and tax-exempt organizations in various employment matters, which brings me to a very important first question for you, Diana, because people are very heated about the specifics of this bill and what it means for independent contractors. In the direct quote of one particularly curious individual, why would I listen to a labor attorney about this topic when she has publicly stated that she wants this bill to pass? Why would I trust that she has my best interests in mind rather than the unions that pay her?
Well, first, Anthony, let me thank you for having me. I'm happy to be here and happy to talk about the PRO Act. And I think that dovetails right into the question, which is, I'm not here to convince anybody one way or the other. I'm a labor attorney. I want the act to pass. You're not going to find a labor attorney in town that doesn't want the act to pass. But what I want to do today is just make sure that folks are educated about what the bill says and what the bill doesn't say. And I don't want anyone to make up their minds about the bill without having been educated or have the chance to ask questions, so that way they can come to a conclusion on their own. You know, I'll also say that I speak pretty often and for both employer side and union side type events. And the reason why you get invited to do those things is because you're able to remain partial and present issues in a way for folks to understand. So that's kind of the game plan today. Just want to go through the act, let everyone know what it's really about, and then answer any questions that folks might have to make sure that when you're making up your mind about if you want to call one of your senators, or if you're in DC, call Eleanor Holmes Norton and thank her for voting for it, then you can figure out how you want to proceed after this event.
Definitely. And while we go through this whole thing, Diana has a presentation that she'll be showing and kind of delving into some of the details of the bill. We have a Q&A function, and the chat is more than open to you guys. If you have any questions in the meantime, if something springs up in your mind while she is presenting or while any other questions are happening, you can be as specific as possible about how it pertains to you and your life as an independent contractor even. We are more than happy to answer your questions just as well as mine. So Diana has prepared a presentation, so you are more than welcome to get into that right away.
Great. I am going to share my screen here. 1 second. And Anthony, let me just ask you, are you seeing the presentation, or are you seeing my
Yes, ma'am.
Okay, excellent.
Technically, we can see both of you, but it's there.
Great. Okay, so the PRO Act, what does it mean for independent contractors? I have an outline here of what we're going to be talking about. And so we're going to go through what the bill is. We're going to talk about what state and federal laws apply to employee relationships as well as contractor relationships. We'll talk about what will happen if the PRO Act passes. What sort of rights might freelancers and independent contractors gain, and what are the potential consequences? And finally, I know there's a lot of talk about how the PRO Act might be similar to California's AB5, and we'll talk about some of the similarities and differences there as well before we get into a Q&A. The PRO Act is draft legislation intended to modernize the National Labor Relations Act. And the questions that freelancers and independent contractors and gig workers have been raising about how this act affects them, you know, it's certainly part of the discussion. But I do want to note that the act is really aimed at addressing a laundry list of issues that exist with the National Labor Relations Act. It hasn't been amended since 1947, and it's been a long time living with the current set of rules that are out there. So it looks to address a number of different issues. It would, right now, employers, when they're faced with a unionizing effort, they can require employees to sit through what's called captive audience meetings. And during those meetings, the employers advocate for the workers to vote against the union. We just saw this happen with Amazon. It's not controversial. I mean, it is in that the labor movement would like to see it end, but these meetings happen. They're known as captive audience meetings, and they're an incredible tool in an employer's toolbox to avoid an election result that they don't want to see. So the act would stop that. It would stiffen penalties for employers for violations of labor law. Right now, if an employer violates labor law, typically the penalties are limited to back pay if someone had been terminated, a piece of paper, a notice that the employer has to put up on the wall saying that they violated the law. And those are really the two things you're limited to, back pay and the notice. And what the act would do would be to assert fines against the company if they were to violate labor law, to act as an additional incentive for folks to comply with the laws. It would also help prevent employers from stalling the bargaining process. After employees decide to vote for a union and they have their union election, on average, it takes almost 1.5 to 2 years to get between your election and your first contract. And that's an extremely long time. And so the act would put in measures to try to bring that amount of time down. And potentially, if you come to what's called an impasse, meaning you can't come to a decision, the act would send those types of disputes where both sides can't come to some sort of agreement. It would send it to a neutral to help the parties figure out how they're going to have a contract. So get the parties to a contract faster, give them more resources to get to that point. It would also protect employees' right to strike by preventing the hiring of permanent replacements. It would also allow unrepresented employees to engage in collective action or class action lawsuits, basically as a way out of mandatory arbitration clauses. If you've been following any of the Supreme Court cases in the past couple of years regarding mandatory arbitration clauses, you might have heard about this. There's a number of times when you're an employee and you might want to sue your employer because, let's say, you've been discriminated. You're a woman, you've been discriminated on the basis of your sex. You want to sue under Title VII, but you might have an employment contract with your employer that you really had no say in that requires you to arbitrate your case rather than take it to court. And so the act would cut down on that ability of an employer to push through those mandatory arbitration clauses and give you access to a court. Also give you access to bring a class action suit with the fellow women that you're working with if all of you have the same claim. Because litigation is expensive, it's helpful to have the economies of scale. If there's 10 women that have been discriminated against, if you can band together and bring one action, it's going to be a lot less costly to pay for the lawyers and the litigation that's required. On the other hand, if each of those 10 women is required to bring their own case, then it's unlikely that all of those cases are going to be litigated just from an expense standpoint. So the act looks to address some of those Supreme Court decisions that have come down in the past couple of years. It also would seek to end right to work laws, which right to work laws say that they're state by state right now. And so some states say that you do not have to pay union dues to your union. This is a problem for unions as it relates to free riders, because even if you don't pay union dues, the union is still required to represent you. So we have cases where folks don't pay us dues, but we still have to represent them when they're terminated from their employer or to get them new contract terms. And so it's been an issue that unions have been battling for a long time, right to work laws, and this would put a federal end to them. Finally, and what we're really here to talk about today, but I wanted to give you all of that context. There's a lot going on in this act. There's a lot to address labor issues. I have lots of opinions on these various aspects that if anyone after this presentation wants to hear more from me about, I'm happy to tell you. But what we're going to talk about today is the facts regarding the bill as to the use of the ABC test to determine whether independent contractors should be considered employees for the purposes of collective bargaining rights. So the PRO Act, what is the status of the bill? It passed the House of Representatives in March, and currently it's sitting in committee. And Leader Schumer has announced that if 50 senators co-sponsor, then he'll put it up for a floor vote. Right now, there's around 45 co-sponsors. Both senators out of Arizona haven't signed on. Mark Warner out of Virginia hasn't signed on, and a couple of others. And there's also, it's currently being tacked on with the infrastructure bill. Unclear to me at this point. I'm not a lobbyist. Legislation is not really where I am, but it looks like there could be a fight over whether or not it can be included within the infrastructure bill as to reconciliation. Obviously, the Democrats have a very narrow majority, and with senators like Joe Manchin, if they're not interested in having this tacked on, then it's unlikely that it'll move forward. It's also unlikely to move forward unless there's some change on the filibuster. So I think the bill is really up in the air right now. It's closer than it's ever been because it has passed the House, and when it was first introduced a few years ago, it didn't make it this far. And obviously there is the very slim Democratic majority, but I would not say any of this is I'm not particularly optimistic, but I am hopeful. So we'll see what happens. So every employee's, and Anthony, I want to make sure, are you seeing the slide that says the laws applicable to employment relations? Yes. Okay, thank you. The every employee's relationship with their employer is controlled by various laws. There are state laws, there are federal laws, there is law that is made by case law, there is law that is by statute. And I'm going to take a minute and tell one of my most famous or infamous law school stories. I was sitting in my contracts class at 8 o'clock in the morning, and I had to share with my study group notes about the criminal law cases for later that day, and I was running behind. So I'm sitting in contracts book open, criminal law book on top of it, typing furiously away on criminal law notes. Halfway through class, my contracts professor says, and Ms. Bardes, you'll answer the next question. I am scared. I have no idea what anyone has been talking about. I have paid no attention. And he says, Ms. Bardes, what's the first question you should ask yourself? And I take a deep breath and I think about it for a minute and I say, what law applies? And he says, Ms. Bardes, you're one of the first people in all of my classes to get that right. So I will move on to the next person. Ms. Santora, why don't you tell me the facts of the case? Huge exhale, right? It's like all my friends were laughing because they knew that I had no idea what was going on. But I knew that the first question you always have to ask yourself in a case is what law applies? And that's really the case here. And why you have to ask yourself that is because there are so many different scenarios that you could be in that the law is different. And that's really the case when we're talking about whether or not someone is an employee. So for example, your state defines employee, and the definition means whether or not you're going to get unemployment insurance. It means whether or not you're going to get workers' compensation, matters for a whole host of benefits. The IRS is also going to determine if you're an employee, right? And if you are, then you're going to be a W-2 employee. Well, the IRS may or may not use a different test than the state that you live in. And then there's a whole host of other federal statutes that have definitions for what an employee is and your eligibility for benefits or rights under those statutes based upon their employee tests as well as their eligibility requirements. So we might be talking about the Fair Labor Standards Act, we're talking about the tax code, we're talking about the National Labor Relations Act, and that's in addition to all the state laws we already talked about. So you can be an employee for the purpose of your state, and you can be not an employee for the purpose of the IRS at the exact same time. And that's the way that our legal system is set up. And so I want everyone to keep that in mind as we start talking about the different tests and how the PRO Act is potentially going to affect independent contractors. Because what we're talking about is how do we define employee, but more specifically than that, how do we define employee for the purpose of the National Labor Relations Act, not for anything else. So with that in mind, we're now going to start going through some of the tests. So here's the biggie that everyone's concerned about, which is the ABC test. And I've included here the language that would be included in the PRO Act. So what the ABC test does is starts from a presumption that you are an employee, which is not a usual presumption in our history of defining employees from a federal perspective. So it starts with the presumption that you are an employee, and you're only an independent contractor if each of the following three aspects are true. So you need to be free from control and direction in connection with the performance of the service, both under the contract and in fact. So what does that mean? That means that does your employer tell you how to do your job, right? So if I'm an Uber driver and I'm being told who I need to pick up, in what order, and how to get there, that means that my employer has control over my job. If I'm a writer and I am allowed to use whatever word processing software I want to, there's no internal deadlines, there's not some requirement that I provide an abstract and then an outline, and then I have to use WordPerfect, and all of my drafts need to be in Times New Roman 12, right? If there's a litany of requirements of what you need to do to get words on the paper, then that's the type of control we're talking about. So if you're not under control, then you're not going to fall under that first aspect of the test. The second aspect of the test is the service is performed outside the usual course of the business of the employer. Now, the ABC test in the PRO Act is a little bit different than ABC tests that some states apply, because some states would have an additional aspect here, and it would be that the services are performed outside the usual course of the business of the employer, or that you don't work on site. So we took out, the PRO Act takes out the work on site aspect of this because we're in the 21st century. And honestly, in the middle of the pandemic, who actually does work on site at their employer? So it doesn't, from the bill's drafter's perspective, that's an update to make more clear the types of workers that would be covered here to become employees. I mean, again, think about an Uber driver, right? They don't work on site at Uber, but I think there's an argument to be made that they should be classified as employees and not contractors. Opinion, you might disagree, but it's a good example. So service is performed outside the usual course of the business of the employer. So what that means is, so again, using Uber as an example, Uber is in the business of driving people. And so if you're a driver, you're in the usual course of business of the employer. If let's say you're a photographer and you are hired somewhat regularly by a banquet hall, the banquet hall is usual course of business is providing banquet food, restaurants putting on events. So you are not in their usual course of business, so you would not fall under that aspect here. So then when we get to the third test, it's whether the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the service performed. So what this is really getting at is, do you do work for one employer, or do you have a business where you're doing this for multiple people? The more you're doing this for multiple people, the more that weighs in favor of you being an independent contractor, versus if you work 40 hours a week on a contract for the same employer, then it's more likely that you have an employee relationship. So these are the three aspects of the test. And if to remain an independent contractor under the ABC test, you would need to fulfill all three aspects. So let's look at some of the other tests that are out there. There's what's called the common law test. In this, when it's applied, states and courts and administrative bodies are kind of weighing factors. It's less of a bright line rule. And so they're looking at whether or not an employer exerts behavioral control, financial control, and it also looks at the relationship between the parties. And it basically weighs these aspects and figures out whether or not you're more like an employee or you're more like an independent contractor. So, and you'll see that some of these really overlap quite closely with the ABC test aspects. So the behavioral control, again, is there, day-to-day rules about how you do your job. Financial control, are you on a set hourly type wage, or do you have some sort of ability to gain profit or loss? Are you reimbursed for your expenses? Are there the types of financial aspects that lean towards saying that there's financial control, in which case you would be an employee? And then looking at the relationship between the parties. What does your contract look like? Does the business provide benefits? Are you in the usual course of the business, or are you doing something outside of the business's usual course? And it's going to look at that. And so it's a bit of a mix, and states that use this test, again, the state and the administrative body, if they're going to do a fact circumstance by circumstance analysis, and that's how you get at your determination of what your characterization is going to be. Last, there's the IRS test. The IRS test is a common law test, but it has 20 specific factors that are looked at. I'm not going to read these out. They are lengthy, but similar to what we've been talking about: amount of training, control. Are you flexible in your schedule? How are you hired and fired? What does your contract say? So it's all very similar things, but again, the IRS has 20 specific factors that they're going to look at to determine whether or not an employer is misclassifying an independent contractor. And then if you are misclassifying them, then there's penalties and you end up being moved to a W-2 employee. Okay, so let's look at the map. So 28 states use either the ABC test or a form of the ABC test to define independent contractors. And so this map shows you kind of how all over the map everyone is, right? I mean, you have the states in orange are pure ABC test. The states in yellow have 2 of the factors. You have the states in blue performing some sort of common law test. Some are performing the IRS test, and some are performing tests I didn't even talk about because each state can do its own thing. But again, that's defining your employment relationship in your state. And your state is where your employment relationship, for most intensive purposes, is where your characterization matters, because state law is federal law only applies very selectively to your employment. So it applies if the National Labor Relations Act is triggered. It applies if equal opportunity is triggered. It applies if fair labor standards are triggered. But federal law only applies on your employment relationship with your employer when it's triggered by one of those statutes. So with that in mind, what does the PRO Act mean for independent contractors? It's only applying the ABC test for the purpose of determining whether a group of workers is protected by the NLRA and thus eligible to unionize. So again, the PRO Act isn't changing anything about your state classification. Whatever your state classification is, it's going to remain exactly the same as the bill is drafted. What the IRS says about you isn't going to change, again, based on the way that the bill is drafted. Whether or not you are eligible for overtime under FLSA, same thing, there's no effect. It's only about whether or not you're covered by the NLRA. So right now, the National Labor Relations Board applies what's called the right to control test. And again, that looks at some of the control factors we've been talking about. It's a little bit of an amorphous case-by-case analysis. And because of that, if a group of contractors want to unionize, those efforts usually fail because the first thing the employer says is, no, they're not employees under the Act, so they are not eligible to unionize. And in most cases, employers win that argument. So using the ABC test, which is more of a bright line rule and a more inclusive rule, again, it has the starting presumption that you're an employee unless you're a contractor versus you're a contractor unless there's control. It's going to be harder for employers to stand in the way of unionization movements on the part of contractors that pass the ABC test that wish to be covered by the National Labor Relations Act. And there's one other aspect of this. So the act will kick in if you and your fellow contractors decide that you want a union, you want to organize, you think it's a good thing for you and you want to do it. And if you pass the ABC test, that means that the act will protect you. The PRO Act will let you do that. If you don't want to unionize, no harm, no foul, the PRO Act has no effect. The other aspect is that there are certain National Labor Relations Act protections that apply to employees defined by the NLRA, regardless of whether or not they're unionized. So I don't think a lot of people know this, but if you're an employee, a company cannot prevent you from talking about your wages or your benefits with your coworkers. And this to me is something that I know a lot of people don't know, and a lot of employers get wrong. I have been shocked at the number of big law firms that tell their associates that they can't talk to each other about their bonuses. That is a straight up violation of the National Labor Relations Act. That associate could run to the board, file an unfair labor practice charge. And unfortunately, like I said, the remedy is going to be a piece of paper that the law firm has to post saying that they violated the act. And there's unlikely to be any back pay or any issue unless there's some sort of retaliation. But I mean, that's a violation of the act. So if you pass the ABC test as a contractor and you want to talk to other contractors who pass the ABC test for the employer for which you're working, you would then have those rights under the NLRA to work collectively with your coworkers, whether that's talking about wages, whether that's talking about other terms and conditions that might make your life better or easier, or addressing issues at your workplace. Those would all be protected, and you couldn't be fired or your contract couldn't be terminated as a result of your having those conversations. So like I said before, a group of workers only unionizes if they choose to. So workers that don't want to organize a union or engage in collective action would be unaffected if the PRO Act passes. It would not stop freelancers or contractors from continuing to do their freelance or contractor work, even if they pass the ABC test. So let's take an example. Software company, it hires 10 contractors. It doesn't want to hire any employees, so it hires 10 contractors to do all the software work. So if those employees pass the ABC test, and if a majority of them decided that they wanted to organize, then they would have those protections. The rights of the National Labor Relations Act would kick in. So if 30% of them decided that they wanted to organize and they were able to show that proof to the board would hold an election. And then a majority of those who vote would need to vote in favor of the union. And if they vote in favor, then the next step is that you would bargain with the employer to come to a contract. Your status as to non-national labor relations act issues would remain unchanged. So for example, in that scenario, according to this bill, you could still be a 1099 employee for the purposes of the IRS and be in a union at the same time. And that's because that's how these laws interplay. A change at one doesn't change the rest of them. It only changes the National Labor Relations Act. So let's take the flip side. The PRO Act passes. None of the contractors for the software company want to unionize. Nothing happens. No harm, no foul, and there's no effect. Or if a majority don't want to unionize, then the election won't pass. And again, there's no issue. Let me throw out one more example I didn't put on the slide, which is, let's say I am the only contractor for the software company, and I want to join a union. I can't. The union has to be at least 2 people. So if there's nobody else but you, then you do not form a bargaining unit, and the board will not process your petition. So we're talking about groups of employees coming together for collective bargaining. If they pass the ABC test under the PRO Act, then they would be able to organize. So we've already talked a little bit about the rights that you would gain. Those Section 7 rights, that's what it's called under the Act. Section 7 is what protects your concerted activity. That's your talking to your coworkers about your terms and conditions of employment. That's finding out, that's other associates asking each other how much money they're making. You know, that is all protected. It also, like we said, provides the right to petition for and join a union and then bargain collectively to a contract. So what would you potentially lose? What are the consequences? Again, if you're not if you don't pass the ABC test, there's as this bill is drafted, there's going to be no effect. If you don't want to unionize, but your co-contractors do, and you all pass the ABC test, I'll run down for you what would happen, right? So the election happens, everyone votes for it, you don't, you are disappointed. What does that mean for you? If you do not want to be a member of the union, again, we're living in a world where the PRO Act has passed, right? So we're in that assumption, which also means that right to work laws are no longer in place. So what that means is that if you don't want to be a member of the union, what you end up doing is paying an amount that is less than full dues. And that's called an agency fee. And that agency fee takes out all of the costs of lobbying that the union spends. So there's complicated calculations for an agency to figure out what full dues are and then subtract out lobbying efforts to come to the agency fee. The Department of Labor very closely monitors the calculation of the agency fees to pull that lobbying out. And so when folks make complaints that it's not being calculated correctly, DOL comes down hard on unions. The one thing to keep in mind is that even if you're paying the lower agency fee, the union still has to represent you. Unions have to represent everybody, whether or not they want to be a member. And like I said, under right to work right now, whether or not they pay dues at all. So how does this differ from AB5? So AB5 used the ABC test. And doing that in a state law context where state law, like I said, governs a very broad range of issues regarding your employment relationship. It created a number of issues in California. I mean, everyone's seen the news, everyone has seen kind of the scramble that occurred. And then to start fixing issues and backtracking, California started putting in piecemeal exceptions. Okay, well, it doesn't apply to this, it doesn't apply to this, it doesn't apply to this. And I can certainly see why folks might be concerned that that would happen here. But the other aspect that I want everyone to remember is we're talking about a very narrow application here, which is only the National Labor Relations Act rights. So whereas in California, you had all these domino effects as to basically every other aspect of an employee-employer relationship, here we're only talking about union organizing. So there should be fewer issues on that going forward on the PRO Act, in my view. Again, the PRO Act does not affect any state laws or state classifications of employees. If you asked, I think if you had asked labor and management attorneys when they read the bill, they would agree with everyone that that's what it said. But a number of groups were concerned. They wanted it to be explicit. So the Authors Guild and the Freelancers Union went to Congressman McBath, who put in an amendment to the bill that specifically says that state laws and state classifications are unaffected by would be unaffected by the passage of the PRO Act. So that's how it would work by operation of law, and now that's also how it works explicitly written into the act. So some common questions that I've seen come up before we get to the Q&A is, I'm a freelancer, but I meet the ABC test definition of employee. Does this mean my company must hire me as a W-2? Again, the answer is no. It has no effect on the IRS application. Same with state law. Again, no effect on state law classifications. A lot of folks have asked, why not just drop the ABC test from the PRO Act? You know, it seems to be causing a lot of division. People have opinions on both sides of this. Why not just drop it? And labor's response to this is that employers often try to stop their workers from organizing by taking advantage of employee definitions. And it's labor's view that the best way to protect the rights of workers in these scenarios is to use an ABC test with a bright line rule that has a presumption that someone is an employee. Reasonable minds can differ here. I'm sure folks here are concerned, as I've seen and I've heard, a lot of folks be concerned that if it's included here, what's to stop it from being included in many other things down the line? And my response to that is that's not what this bill says. And so if that comes up in a future bill, then the time to be upset about that is then. But here, this act is limited in its application. Does the PRO Act force me to be in a union? Again, no. If you want to organize and you pass the ABC test, great, we'd love to have you. But if not, it's only going to affect you if you choose. I've seen some questions about some folks being a little confused about how bargaining units are constructed. The PRO Act itself doesn't say what an appropriate bargaining unit is, but at the same time, the Act says that 30% of people in an appropriate unit have to want a union in order to get an election. So how does that work? And why is there this gap in the law? And the answer to that is pretty simple, which is not everything that's law is written into the US code. So like I said, the NLRA was passed in the 30s, and the amendment called Taft-Hartley was passed in the 40s. And since that time, the National Labor Relations Board, which is the enforcing authority, has built a long established precedent of law that's looked at for these issues. And so only appropriate bargaining units move forward to an election. There's a whole set of rules that go into that. And I guarantee you, if there's an argument to be made that someone is not an appropriate bargaining unit, that the employer is going to make that argument and fight tooth and nail for the election not to go forward on the basis that you're not appropriately connected. So that's something to keep in mind. Would antitrust law have any effect here? Is another question that I've seen a lot out there. And it's true that antitrust prevents companies from colluding to set prices, but the NLRA is an exception. So if you're an ABC test employee and you fall under the NLRA, then it's not collusion for you to work to set prices and collectively bargain with your coworkers. And again, the IRS test is unchanged. So with that, I will turn off my screen share and ask Anthony if there are more questions out there, which I'm sure there are many.
Definitely, and there are going to be a lot of very situation-specific questions, because even with all this information, it is a lot to digest.
Absolutely.
And everyone has their own situation. That's kind of the beauty and the nature of independent contracting and being a freelancer, is that your situation is so unique to yourself and your clients and how you operate your business. So we'll start.
Let me say as a disclaimer before you get into the questions that I can't provide anyone with legal advice, right? So I'm going to do my best to answer your questions to the best of my ability. But if you have specific concerns that you're worried about liability or anything like that, you should find an attorney to speak to. I'm going to do my best to answer your questions, but not legal advice. Good
call. Good disclaimer. If I am a content writer or graphic designer who operates as a sole proprietor, this is their main line of work. Does that mean companies who want my service will need to bring me on as an employee? I think you kind of covered a bit on that topic already.
Yeah, again, probably, like, depends if you're going to, again, no, they don't have to bring you on as an employee. It's going to be whether or not you want to organize with coworkers that are similarly situated. And if you do, then you'll be an employee for the purposes of the NLRA, but you won't be an employee for any other purpose if you aren't currently under any other law.
As a sole proprietor, how will this affect my ability to subcontract work to others?
Yeah, that's a good question, because if you're subcontracting work out to others, then you're potentially the employer in that situation. So with that being the case, you probably want to think about your arrangements, because if you have a number of subcontractors that you use regularly and they work full-time for you and you control them and they work in the same line of work as you do and they're going to pass that ABC test, if they become frustrated with their work situation and want to unionize, then you are going to have a unionization effort on your hands. So it's important from that perspective, if you're the employer in that scenario, to think about how you're structuring your subcontracting agreements, either to avoid the ABC test or treat your employees well such that they don't want to go about an organizing effort.
Is unionizing the only way for this to become a valid concern for a sole proprietor?
In my view, yes. Unionizing, or if you go around just violating the act, if you go around telling people, don't talk to each other about your wages or your terms and conditions of employment, then you could be like those big law associates that I said that might be able to run down and get their board complaint handled. But those are really the two things we're talking about. Unionizing being a concern, and violating people's rights to act in concertedly with their coworkers.
Gotcha. This individual has clients in multiple states. They want to know if the law will make some clients be required to classify me differently in their state versus another client in another state.
Again, there's no effect on state classifications, so the answer to that is no.
And that will only come up if that state passes legislation to a similar effect, correct?
Exactly, and you might already be in a state that applies the ABC test.
How will this affect businesses that hire day laborers?
This is an interesting question that has less to do about the PRO Act and more to do about National Labor Relations Act and what an appropriate bargaining unit is. There have been efforts, the board has issued some decisions in recent years allowing temp workers to unionize, but those have been in more temp agency scenarios, and those rules apply there. As to day laborers, because they're so temporary in their employment, if you're not hiring the same person every day, then it's less, right? If you're doing that right now, your problem isn't the PRO Act, your problem is whether or not those people could organize right now under the law as it stands, and the PRO Act's not going to change that one way or the other.
How does being registered as a sole proprietor versus being registered as an LLC change how the law affects a business?
So this question, and this is a large reason why I asked that folks submit their questions early, because this question was really interesting to me. And honestly, I don't have a clear answer for you. The bill doesn't say. But in my view, I would think that if you were an LLC, it would be harder to it would be harder to unionize, because the employer would say, no, that's not an individual, that's a company. And there would be, there's corporate law issues regarding piercing the corporate veil. If you've set yourself up as an LLC, you probably know that, and that's why you did it. It lessens your liability. And so adding that additional type of corporate structure, I think, is going to make it more difficult for an organizing campaign to get off the ground. Again, the bill doesn't say one way or the other. I'm giving that answer based upon my experience in labor law. That's one of those things that's probably not going to get written into the bill, and it's, that's something that the NLRB would decide down the line. But certainly, I think an LLC might provide an extra layer of protection between, or protection or prohibition, depending on how you want to look at it, for moving towards a unionized situation.
Yeah, no, that was a particularly tough question with a lot of caveats and just things that aren't clear based on the language of the bill. We may be reiterating a little bit, but another question is, how does the PRO Act affect established state-based definitions of who an employee is?
Again, there's no impact.
Yeah. How does this affect someone like an event photographer who might work for individuals like a wedding or doing senior photos or something like that, in that you're not being contracted under an employee, but under one individual client?
Yeah, if you have one individual client, and even if that client hires you a lot, that's not going to get you, well, there's a couple aspects to that. One, you can't have a bargaining unit of one. So it would have to be, they always hire you and your photography partner. And then the two of you would need to decide, and then you would need to overcome whether or not you're an appropriate bargaining unit. Do you work enough? Are you are you photographing once a month? That's not going to get you over the hump. So in most cases, if you're freelancing for a wide variety of individuals out there, and you're not working for anyone significantly, and it's more one-offs, then this act is not going to have an effect.
This is kind of a combined question from a couple people that have had similar sentiments. Most of my work is subcontracting with clients that do happen to do work in the similar course of that business. Though I have other clients, is there anything that I should be concerned about?
Well, it depends on what your concern is, right? And how you're looking at it. If you are doing work in the same course of business as the company does, then under the ABC test that's contained in the PRO Act, you're going to be found to be an employee, again, for the purposes of the National Labor Relations Act. So what do you have to be worried about if you don't want to organize? Then your concern would be whether there are other similarly situated contractors performing the same work as you for the same employer, and those people want to unionize. That would be your concern, that you would be on the outside of that if you didn't want it to happen. But on the flip side, I would view it as an opportunity that would allow you to band together with those similarly situated folks that work for the same employer and advocate for yourselves should you ever find yourself needing to do it.
Regarding the control and direction aspect of the ABC test, how does that affect those who contract for the government or other clients who do have very, very strict working guidelines? Does that kind of fall into the same answer?
Yeah, same answer.
Gotcha. Okay.
Well, and actually, let me say one more aspect to that, which is the National Labor Relations Act only applies to private employers. So the government contracting out to you at PRO Act, no effect because they're a public employer.
Got it. Good and important distinction. How can contractors in any state navigate a potential situation in which a prospective client doesn't understand the law and refuses to hire a service provider as a contractor?
Difficult question, right? Someone that just doesn't want to educate themselves on the facts, and how do you deal with that? Education, showing them the act. There's a lot of different fact sheets out there by various, in my view, reputable organizations that kind of lay this out. And so but I mean, if people don't want to understand the facts of how the ABC test applies or what it applies to, you're going to have a problem. And like I said, if you're already in a state that has an ABC test law, then this isn't really going to be that different. But yeah, it's a tough situation.
A direct read from your example, it doesn't seem like the software developers working for a software company would be allowed to be independent contractors because it isn't separate from the primary purpose of the business. This individual is a writer. Can they not work for a media company as an independent contractor because it's the primary purpose of that media company?
Well, again, your employment relationship is going to be dictated by the state, whatever test is applied by your state. So if your state is applying the IRS test or the common law test, you're still an independent contractor. You're only potentially going to be classified as an employee if you want to take advantage of your rights under the National Labor Relations Act. So again, we're not changing any classifications. It's just if you want to avail yourselves of what rights are available to you under the NLRA, that door will be open for you and you can walk through it if you want to, but no one's forcing you to walk through the door. We're just putting a door there.
This is more of a kind of a request for information, but someone wants to know what it might look like for freelancers to unionize. What steps might be taken to go in that direction?
Yeah, absolutely. And if folks have more specific questions, feel free to shoot me an email. And I'm happy to try to connect you with folks that are involved in the organizing movement to send you in that direction. My advice would be that, right now it's very difficult because of the current state of the tests. That doesn't mean that there isn't opportunity if there's a chance you're being misclassified under the current test. There's also various organizations that know that they don't have the ability to actually unionize or be unions. For example, the freelancers union that I mentioned before. There's also a writers guild that my firm works with, that they know they're not unions, but they're doing their best to be involved in activities that promote better working conditions. So if you're interested in those types of issues, feel free to shoot me an email, and I can send you in the direction of some more actual union resources in places that you might want to go.
Gotcha. Thank you so much. And then the last thing, what, and this is more of a personal opinion sort of thing for you. What do you think were this bill to be passed, what precedent would that send and set for future legislation potentially?
Yeah, I understand that concern. But I view, in law school, they teach you to be skeptical of slippery slope arguments. And I think that's really what this is. Again, in my view, that, if this act passes, then what's to stop it from applying to the IRS, which would be a really big deal. What's to stop it from a federal law now announcing how all states are going to classify their employees? I just don't think that those scenarios are as likely as this scenario, as to come up as this scenario is. I know that the Biden administration put out some statements saying that they view the ABC test as a test that should be applied across the board. I don't necessarily know that I agree with that. I don't, people can certainly have views multiple ways on that. I know that's going to face a lot of resistance, even more than this act is. To change it for the IRS is going to be huge. The outcry coming from all sides, I think, would be even greater than we're potentially hearing here. And this is a pretty narrow issue. So I guess that's my sense on that. It's just, we have a bill in front of us that, in my view, is going to do a lot of really good things to fix issues. And also, I would err on the side of providing labor protections to folks that need it. And so if I'm a contractor who would be seen as misclassified under the ABC test, and I'm being treated poorly at work, and I want to work together with my coworkers to stand up for ourselves, then I'd rather err on the side of giving those folks the ability to do so. And at the same time, saying to the rest of you that don't want it, that's fine. You don't have to have it, but those that need it or those that want it can. And so that's why I think setting the rule up the way it is makes sense. But obviously, reasonable minds disagree on that point.
And I think that will come, if it does come down to it, I think it will arise in the sense of lack of endorsements or co-sponsorships and potential amendments that end up happening on the other side. So if it does end up passing as is, then now we have at least a bedrock information on what it means for us as freelancers and what it means for the rest of the working world in the sense of unions. So thank you so much, Diana, for your expertise. If you have any other things that you'd like to share with us or any thoughts you weren't quite able to get to before.
No, I think that covers it. I just want to thank you again. I just want to, I'm glad that you guys asked me to come. I'm always happy to answer questions. My life's work is making sure that workers have the ability to take advantage of the rights that are afforded to them. And so want to make sure that people are educated on these issues. And so that way they can make the best decisions for themselves.
Great. Well, thank you so much. Would you mind putting your email in the chat if anybody wants to get in contact with you about any specific questions or anything that may not have come up to mind during your presentation or during the Q&A session?
Yes.
While you're doing that, thank you guys, everyone who's attending, so much for coming. I want to give a little bit of more information about Freelance DC. As I mentioned in the beginning, we're a community of freelancers that are really just about supporting each other and continually working to protect and improve the lives and rights of independent contractors, really no matter what you do, whether you're in the gig economy, whether you're just doing it sometimes for whatever reason on the side hustler. We want to support you, we want to help you, and we want to kind of be that sounding board. So if you are interested in kind of being aligned with us and are a freelancer, then you're welcome to join the Facebook group. Misha just posted in the chat. And we've also got a website. you can check out. And we will actually be doing a sort of a debrief on this meeting, this conversation, tomorrow at 11 a.m. We do a coffee chat every week, and we may or may not have a couple experts in that meeting as well, kind of talking about their perspectives and their opinions. And now that we are all more informed, we can kind of debate a little bit in a more educated way. So thank you guys again so much. Have a wonderful night, and spread the word about what you've learned tonight.